palace walls are trembling tonight, and it's not from any earthquake. Word is leaked from sources close to the Sussex camp that Meghan Markle is preparing what might be the most audacious legal challenge in modern royal history. She's reportedly threatening to sue Prince William if he dares strip her of the Sussex title when he ascends the throne. Yes, you heard that correctly. The former cable television actress believes she can take the future King of England to court over a title that was never actually hers to begin with. This bombshell revelation has sent shockwaves through both Buckingham Palace and legal circles, with constitutional experts barely able to contain their laughter at what they're calling the most delusional move yet from the Montecito mansion. But here's where it gets absolutely fascinating. Sources whisper that Meghan genuinely believes she has a strong legal case, apparently convinced that her years of clinging to the Duchess of Sussex styling gives her some form of ownership over the title itself. The timing of this threat couldn't be more telling. Just weeks after King Charles demonstrated his absolute authority by stripping Prince Andrew of his titles with nothing more than a letters patent, Meghan is reportedly in full panic mode. Palace insiders suggest she's been frantically consulting with lawyers, desperately seeking someone who will tell her what she wants to hear rather than the brutal constitutional reality. What makes this even more extraordinary is that Meghan seems to have completely missed the lesson from Andrew's swift downfall. When the king decided enough was enough, with his brother's associations, it took mere paperwork to remove decades of royal styling. No courts, no appeals, no lengthy legal proceedings, just the sovereign's will made manifest through the ancient mechanism of letters patent. But Meghan's American perspective appears to have blinded her to this fundamental truth about how the British monarchy operates. She's reportedly been telling confidants that she believes her situation is different, that somehow her years of using the Sussex title in Hollywood, deals and charity work, gives her legal standing that Andrew never possessed. The irony is almost too rich to believe. This is the same woman who once told Oprah Winfrey that titles meant nothing to her, yet now she's apparently prepared to wage legal warfare to keep the very styling she once claimed to despise. Palace sources suggest that behind the scenes, William's team is practically encouraging this legal threat, viewing it as the perfect opportunity to expose once and for all just how little Meghan understands about the institution she married into. What Meghan fails to grasp is that royal titles aren't property to be owned or fought over in court. They're privileges granted entirely at the pleasure of the crown, revocable at any moment the sovereign deems appropriate. But as we're about to discover, her fundamental misunderstanding of this basic constitutional principle is about to lead her into the most humiliating legal defeat imaginable. The sheer audacity of Meghan's position becomes even more staggering when you understand the fundamental legal reality she's apparently chosen to ignore. Royal titles in Britain don't work like Hollywood contracts or American property rights. They're not assets you can own, trade, or defend in court. They are quite literally gifts from the crown that can be withdrawn at any moment without explanation, compensation, or legal recourse. Constitutional experts are having a field day with Meghan's reported legal strategy, with one senior barrister describing it as, quote, the most legally illiterate position taken by anyone connected to the royal family in living memory. The problem isn't just that Meghan misunderstands British law, it's that she fundamentally miscomprehends the very nature of monarchy itself. Here's what Meghan apparently doesn't grasp. She was never given the title Duchess of Sussex. Her husband Harry received the Dukedom of Sussex as a wedding gift from his grandmother, Queen Elizabeth. Meghan's styling as Duchess comes purely through marriage, making her what constitutional scholars call a courtesy Duchess. She has no independent claim to the title whatsoever. No more than any other spouse of a peer has independent ownership of their husband's hereditary honors. But sources close to the Sussex camp suggest Meghan has convinced herself that her years of commercial exploitation of the Sussex brand somehow creates legal standing. She's reportedly pointed to her use of the title in business ventures, charity work, and media appearances as evidence of her vested interest in maintaining the styling. Legal experts describe this reasoning as breathtakingly naive about how British constitutional law actually operates. The reality check gets even harsher when you consider that Meghan isn't even properly using the title she's so desperate to protect. Protocol dictates that only blood royals can place their ducal title before their name. Meghan should be styled as Meghan, Duchess of Sussex, not Duchess Meghan, as she often presents herself. Yet she's apparently prepared to sue to defend a title she's been misusing from day one. Palace insiders reveal that this fundamental misunderstanding runs even deeper. Meghan has allegedly suggested to associates that her situation differs from Prince Andrew's because she, quote, earned her title through years of royal service. The constitutional absurdity of this position cannot be overstated. Royal titles aren't employment benefits that become vested after a certain period of service. They're honors that exist entirely at the pleasure of the sovereign. What makes this even more remarkable is the timing of her legal threats. Just as King Charles has demonstrated the speed and finality with which royal titles can be removed, Meghan is apparently doubling down on her claim to permanent ownership of a styling that was never truly hers. Sources suggest that rather than learning from Andrew's swift downfall, she's chosen to interpret it as motivation to preemptively strike before William has the chance to act. But as we're about to see, her Her American perspective on legal rights is about to collide catastrophically with the ancient realities of British sovereign power. The legal community's response to Meghan's reported lawsuit threats has been nothing short of brutal. Constitutional lawyers across Britain are describing her position as, quote, legally frivolous to the point of embarrassment, with several prominent barristers suggesting that any solicitor who takes her case should consider their professional reputation carefully before proceeding. The fundamental problem with Meghan's strategy becomes crystal clear when you examine the legal precedents. No court in British history has ever successfully challenged the Crown's authority to grant or revoke titles. The concept of judicial review simply doesn't apply to the sovereign's prerogative powers over honors and dignities. As one King's Counsel put it, quote, Meghan might as well try to sue God for making it rain. But the legal impossibilities run even deeper than simple precedent. British courts operate under the principle of crown immunity, meaning the sovereign cannot be sued in their own courts without explicit consent. Any attempt by Meghan to challenge William's future decisions would require the very monarch she's trying to sue to agree to be sued. Legal experts describe this as a constitutional catch-22 that makes her entire strategy dead on arrival. Sources familiar with Meghan's thinking suggest she's been exploring the possibility of filing suit in American courts, apparently believing that U.S. jurisdiction might somehow override British constitutional law. Legal scholars on both sides of the Atlantic are describing this approach as spectacularly misguided. American courts have no authority over British royal prerogatives, and any U.S. judge attempting to rule on British titles would be laughed out of international legal circles. The sovereignty principle makes Meghan's position even more hopeless. Royal titles exist within the British constitutional framework as expressions of the monarch's personal gift. They're not commercial property protected by international trade law, not intellectual property subject to copyright protection, and certainly not contractual rights enforceable through litigation. They are, as constitutional expert Professor Vernon Bogdanor explains, quote, entirely creatures of royal grace, existing only as long as that grace continues. Perhaps most damaging to Meghan's reported legal strategy is the recent precedent set by Prince Andrew's title removal. The speed and finality of that action demonstrated beyond any doubt that the Crown's authority over titles is absolute and immediate. No lengthy legal proceedings, no compensation discussions, no appeals process, just the sovereign's will implemented through letters patent. The same mechanism used for centuries to create and destroy noble honors. Legal experts are particularly scathing about reports that Meghan believes her commercial use of the Sussex brand somehow creates proprietary rights. As one senior constitutional lawyer observed, quote, using a title for business purposes doesn't create ownership any more than renting a house creates property rights. The title belongs to the Crown, full stop. The consensus among Britain's top constitutional minds is unanimous and devastating for Meghan's position. She has no legal standing, no viable jurisdiction, and no constitutional foundation for any challenge to royal title decisions. The Andrew precedent has sent shockwaves through the Sussex camp, and for good reason. What happened to Prince Andrew in those crucial weeks serves as a masterclass in just how swiftly and decisively the Crown can act when patience finally runs out. King Charles didn't need congressional approval, didn't require judicial review, and certainly didn't seek Andrew's permission. One letter's patent later, decades of royal styling simply evaporated. Palace insiders reveal that Meghan watched the Andrew situation unfold with growing horror, finally understanding that her assumptions about title security were catastrophically wrong. Sources suggest she initially believed that Andrew's association with controversial figures made his situation unique, somehow different from her own circumstances, but constitutional experts quickly disabused her of that comfortable delusion. The mechanism used against Andrew is the same ancient procedure that could be deployed against any royal title holder at any time. Letters patent represent one of the Crown's most powerful constitutional tools, dating back centuries and requiring no external validation or approval. When King Charles decided that Andrew's continued use of royal styling was inappropriate, the administrative machinery moved with ruthless efficiency. What makes Andrew's downfall particularly instructive for Meghan's situation is the complete absence of legal recourse. Andrew, a blood royal who held his titles by birthright, had no avenue for challenge or appeal. If someone with his constitutional standing couldn't contest the Crown's decision, what possible hope could a courtesy duchess have of mounting successful legal resistance? But sources close to Meghan suggest she's drawing exactly the wrong lesson from the Andrew precedent. Rather than recognizing the futility of challenging royal authority, she's apparently convinced herself that preemptive legal threats might somehow deter future action against her own titles. Constitutional lawyers describe this strategy as not just legally hopeless, but potentially suicidal for her public position. The Andrew situation also demonstrated something crucial about public opinion and royal titles. When the decision came down, there was no significant backlash, no constitutional crisis, no international incident. The British public largely supported the king's decisive action, viewing it as appropriate housekeeping rather than monarchical overreach. This precedent suggests that similar action against the Sussex titles would likely be met with widespread approval rather than controversy. King Charles's handling of Andrew also revealed the monarchy's willingness to act against family members when institutional interests require it. The days of protective cover for wayward royals appear definitively over, replaced by a more business-like approach to royal reputation management. Meghan's apparent belief that family connections might shield her from similar action seems increasingly naive given this new royal reality. Perhaps most ominously for Meghan, the Andrew precedent established that royal titles can be removed not just for criminal behavior, but for conduct deemed inappropriate for someone holding royal honors. The constitutional crisis that Meghan's threats could trigger extends far beyond a simple dispute over titles. Her American citizenship adds layers of complexity that could transform this from an embarrassing legal miscalculation into a full-blown diplomatic incident with consequences she clearly hasn't considered. Constitutional scholars are warning that her aggressive stance could activate dormant legal mechanisms that would leave her in a far worse position than simply losing a title. The United States Constitution contains a little-discussed provision known as the Titles of Nobility Amendment, which prohibits American citizens from accepting foreign titles without congressional consent. While this amendment has never been ratified, parallel principles exist in current U.S. law that could create serious complications for Meghan's citizenship status if she's seen as aggressively defending her claim to British noble honors. Legal experts on both sides of the Atlantic are quietly discussing whether Meghan's reported lawsuit threats could be interpreted as choosing foreign allegiance over American citizenship. The principle behind these laws stems from the Founding Fathers' determination to prevent Americans from developing divided loyalties through foreign honors and titles. If Meghan is seen as prioritizing her British ducal status over her American identity, it could trigger citizenship review processes she's apparently never considered. But the constitutional implications run deeper than Meghan's personal legal jeopardy. Her threats represent an unprecedented attempt by an American citizen to use litigation to interfere with British constitutional processes. Foreign policy experts warn that this could create diplomatic tensions between two allied nations, with the U.S. potentially being forced to distance itself from one of its own citizens' legal adventurism. Palace sources suggest that Buckingham Palace is already engaging with the Foreign Office about the potential implications of an American citizen attempting to sue the British Crown. The concern isn't just about the immediate legal impossibility of such action, but about the precedent it might set for other foreign nationals who hold British honors to challenge royal prerogatives through foreign court systems. The timing of Meghan's threats also creates maximum constitutional awkwardness. With King Charles having just demonstrated the absolute nature of royal authority through the Andrew precedent, any attempt to challenge that authority through litigation appears to be a direct assault on monarchical sovereignty itself. Constitutional experts warn that this goes far beyond personal grievance into territory that could be interpreted as fundamentally hostile to the British constitutional system. What makes this even more concerning for Meghan is that her reported legal strategy seems designed to create exactly the kind of constitutional confrontation that would force both governments to choose sides. The British government would be constitutionally obligated to defend royal prerogatives, while the American system would be reluctant to support what appears to be foreign meddling in an allied nation's constitutional processes. Legal scholars are warning that Meghan appears to be sleepwalking into a constitutional crisis that could leave her isolated from both countries. The response from Prince William's camp to Meghan's reported legal threats has been everything you'd expect from a future king who understands exactly where he stands constitutionally. Palace insiders reveal that when word of Meghan's lawsuit intentions first reached William's team, the reaction wasn't panic or concern, but something far more devastating for Meghan's position. Confident amusement. Sources close to the Prince of Wales suggest his immediate response was reportedly, quote, "Bring it on," a reaction that speaks volumes about how seriously the future monarch takes Meghan's legal posturing. Constitutional advisors have apparently assured William that any such challenge would not only fail spectacularly, but would actually strengthen the monarchy's position by demonstrating the absolute nature of royal authority to a global audience. What's particularly telling about William's confidence is how it contrasts with the reported anxiety emanating from Montecito. While Meghan is allegedly scrambling to find lawyers willing to take what most consider an unwinnable case, William's team is reportedly treating the entire situation as a welcome opportunity to finally settle the Sussex question once and for all. Palace sources suggest there's almost an eagerness to see Meghan follow through on her threats. The strategic thinking behind William's relaxed response becomes clear when you consider the broader constitutional context. Any legal challenge from Meghan would require her to publicly argue that she has ownership rights over a British royal title, a position so constitutionally absurd that it would effectively discredit her remaining claims to royal connection. William's advisors apparently view this as a win-win scenario. Legal experts close to the palace are reportedly advising that Meghan's threats actually provide the perfect justification for preemptive action. If she's publicly claiming ownership of royal titles and threatening litigation to defend that ownership, it could be argued that she's fundamentally misunderstanding her relationship with the crown in ways that make her continued use of royal styling inappropriate. But perhaps most damaging for Meghan's position is the reported reaction from other members of the royal family. Sources suggest that even royals who previously advocated for a softer approach to the Sussex situation are now viewing Meghan's legal threats as crossing a constitutional red line that demands decisive response. The unity of royal opinion against her position reportedly extends even to family members who once hoped for reconciliation. William's team is also said to be quietly pleased about the timing of Meghan's threats, coming so soon after King Charles demonstrated the swift efficiency of royal title removal through the Andrew Precedent. Meghan's aggressive stance provides perfect political cover for similar action against the Sussex titles. Public opinion would likely support removing titles from someone actively threatening to sue the crown. The confidence radiating from William's camp extends to their apparent certainty about public support for any future title removal. The sovereignty shield that protects the British crown from legal challenge represents one of the oldest and most absolute principles in constitutional law, and it's precisely what makes Meghan's reported lawsuit threats so spectacularly doomed to failure. No court on earth possesses the jurisdiction to second-guess the sovereign's decisions regarding royal honors, and any lawyer who suggests otherwise is either deliberately misleading their client or fundamentally ignorant of basic constitutional principles. The doctrine of sovereign immunity didn't develop by accident. It emerged from centuries of constitutional evolution that recognized the fundamental impossibility of having the crown subject to its own courts. As constitutional expert Professor David Starkey explains, the monarch cannot be sued in their own courts because those very courts derive their authority from the crown itself. It would be like expecting someone to successfully sue themselves. But Meghan's reported legal strategy appears to misunderstand sovereignty at an even more basic level. Sources suggest she's been exploring whether international courts might have jurisdiction over British royal titles, apparently believing that globalization somehow trumps national sovereignty in constitutional matters. Legal experts describe this approach as breathtakingly naive about how international law actually operates. The European Court of Human Rights, often suggested as a potential venue for challenging British government decisions, has no authority over royal prerogatives regarding honors and titles. These matters fall squarely within the domestic constitutional arrangements of member states, explicitly protected from external interference. Any attempt to drag the British crown before international tribunals would be dismissed without consideration. Even more problematic for Meghan's position is the principle of royal prerogative itself. Constitutional scholars explain that certain powers remain entirely within the sovereign's personal discretion, immune from judicial review or legislative interference. The granting and revocation of honors sits at the very heart of these prerogative powers, representing one of the last areas where monarchical authority remains absolute and unchallenged. Palace constitutional advisors are reportedly relishing the opportunity to educate Meghan about these realities through actual legal proceedings. Sources suggest there's almost pedagogical enthusiasm about the prospect of having British courts formally explain to an American plaintiff why her understanding of royal authority is so fundamentally flawed. The educational value alone would justify the modest expense of legal response. The global implications of Meghan's threats extend far beyond her personal situation. If foreign nationals could successfully challenge royal decisions through litigation, it would undermine the sovereignty of every constitutional monarchy worldwide. The precedent would be constitutionally catastrophic, which is precisely why no court would even consider entertaining such a challenge. Legal scholars are pointing out that Meghan's threats actually strengthen rather than weaken royal authority by forcing public discussion of just how absolute that authority really is. The Hollywood humiliation awaiting Meghan if she follows through on her legal threats would be unprecedented in its scope and devastating in its consequences. Entertainment industry insiders are already whispering about how such a spectacular legal defeat would effectively end any remaining credibility she might have in American celebrity circles, transforming her from controversial royal exile into laughingstock pariah overnight. The optics alone would be catastrophic for someone whose entire post-royal brand depends on maintaining some semblance of dignity and relevance. Picture the headlines when British courts inevitably dismiss her case without even dignifying it with a full hearing. Legal humiliation on this scale doesn't fade quietly into obscurity. It becomes the defining moment that overshadows everything else about a public figure's legacy. Hollywood operates on perception and power dynamics, and nothing destroys both quite like being publicly schooled by constitutional experts on basic legal realities. Sources within the entertainment industry suggest that Meghan's reported legal threats are already being discussed in executive circles as evidence of someone who has completely lost touch with reality. The consensus appears to be shifting from viewing her as difficult but potentially valuable to seeing her as fundamentally unmanageable. The financial implications would extend far beyond legal fees. Any major brand or production company would think twice about associating with someone who had just suffered such a public constitutional education. Insurance companies would likely view her as a liability risk, given her apparent willingness to pursue legally frivolous challenges against sovereign governments. The reputational damage would be quantifiable in lost opportunities and canceled deals. But perhaps most damaging would be the revelation of just how little Meghan understands about the very institution she spent years criticizing. Her legal challenge would force public examination of her claims about royal protocol, constitutional law, and monarchical procedure. Legal experts would inevitably dissect her public statements, revealing a pattern of fundamental misunderstanding that would undermine every criticism she's ever made about the royal family. The international embarrassment factor cannot be overstated. This wouldn't be a private legal dispute quietly resolved behind closed doors. Constitutional challenges to royal authority become matters of global interest, covered extensively by international media and legal scholars worldwide. Meghan would become a case study in constitutional ignorance, her name forever associated with one of the most legally illiterate challenges in modern royal history. Entertainment lawyers in Los Angeles are reportedly already advising their clients to distance themselves from the Sussex brand, viewing association with such legal recklessness as potential career suicide. The Hollywood machine has little tolerance for sustained negative publicity, especially when that publicity makes someone appear fundamentally unhinged from legal and constitutional reality. The cascading effects would extend to every aspect of Meghan's public persona. The titles trap that Meghan appears to be walking into becomes even more sinister when you examine the potential citizenship consequences of her aggressive legal stance. What she apparently hasn't considered is that her very threats to sue over British royal titles could trigger scrutiny of her American citizenship status under laws specifically designed to prevent exactly this kind of divided loyalty scenario. The United States has always maintained strict principles about citizens accepting foreign honors and titles, dating back to the Founding Fathers' determination to prevent the kind of aristocratic corruption that plagued European politics. While the original Titles of Nobility Amendment was never fully ratified, similar principles exist in current immigration and citizenship law that could create serious legal jeopardy for Meghan's status as an American citizen. Immigration lawyers are quietly noting that Meghan's reported willingness to sue to defend her claim to a foreign noble title could be interpreted as choosing foreign allegiance over American citizenship. The legal principle is clear: American citizens cannot owe primary loyalty to foreign sovereigns or aggressively defend claims to foreign honors without potentially triggering citizenship review processes. But the trap gets even more complex when you consider the timing of her threats. By publicly declaring her intention to fight for her Sussex titles, Meghan is essentially announcing that she views these foreign honors as more important than potential conflicts with American law. This kind of public prioritization of foreign noble status over American citizenship principles could provide grounds for citizenship challenges she clearly hasn't anticipated. Constitutional scholars point out that the irony of Meghan's position is almost poetic. In her desperation to keep British titles she doesn't actually own, she could end up jeopardizing the American citizenship that represents her only real legal protection against royal authority. American citizenship is what gives her the theoretical right to criticize the British monarchy without fear of direct retaliation. Lose that protection, and she becomes subject to British law in ways she clearly hasn't considered. The precedent for citizenship challenges based on foreign allegiance isn't theoretical. American history includes numerous cases where citizens lost their status for demonstrating primary loyalty to foreign governments or institutions. While these cases typically involved more serious matters of state, the principle remains that American citizenship requires undivided loyalty to American constitutional principles over foreign honors. Legal experts are suggesting that Meghan's threats could actually provide the perfect test case for modernizing citizenship law around foreign titles and honors. Her high-profile status and aggressive stance make her an ideal candidate for establishing new precedents about how American citizens can and cannot interact with foreign noble institutions. The ultimate irony would be Meghan losing both her American citizenship and her British titles through the same legal adventurism. The royal reckoning that awaits Meghan represents far more than just the failure of a misguided legal strategy. Her desperate move to threaten litigation over titles she never owned signals the complete collapse of whatever relevance she once possessed in royal circles, marking what constitutional experts are calling the definitive end of the Sussex experiment in freelance royalty. Palace insiders reveal that Meghan's legal threats have achieved something that years of public criticism and media attacks never could: They have united the entire royal establishment in recognition that the Sussex situation requires final resolution. Where once there might have been family sentiment arguing for patience or accommodation, there is now institutional consensus that Meghan's fundamental misunderstanding of royal authority makes her continued association with the monarchy untenable. The strategic brilliance of allowing Meghan to pursue her legal threats becomes clear when you consider the broader constitutional context. Rather than appearing to act vindictively against family members, the royal family can now position any title removal as a measured response to direct legal aggression against the crown itself. Meghan has essentially provided the perfect justification for the very action she's trying to prevent. Constitutional historians are already noting the precedent this situation will establish for future generations. The Sussex case will become the definitive example of why the monarchy's authority over titles and honors cannot be subject to external challenge, regardless of the challenger's previous royal connections or public profile. Legal textbooks will cite Meghan's failed challenge as the moment when modern royal prerogative was tested and decisively upheld. But perhaps most tellingly, sources close to the royal family suggest there's genuine relief that the Sussex situation is finally reaching its inevitable conclusion. Years of uncertainty about how to handle two family members who refuse to accept the consequences of their departure from royal duties are apparently giving way to clarity about the constitutional impossibility of their position. The international implications extend far beyond Britain's borders. Constitutional monarchies worldwide are watching this situation with intense interest, recognizing that the principles at stake affect every modern royal house. The precedent of successfully challenging royal authority through litigation would undermine monarchical systems globally, which is precisely why no court will entertain such challenges. Meghan's threats have also crystallized public opinion in ways that purely administrative action might not have achieved. By positioning herself as someone willing to sue the crown over titles, she has moved from sympathetic figure wronged by royal protocol to aggressor challenging the very foundations of constitutional monarchy. The shift in public perception has been swift and decisive. The ultimate tragedy of Meghan's position is that her desperate attempt to secure her royal connection will likely achieve exactly the opposite result, providing the constitutional justification and public support necessary for the very title removal she's trying to prevent.